question? Or go ahead.
Does I? Okay. Hi everyone, my name is Sarah Durham. I'm one of the post-conviction attorneys here at Blizzard and Zimmerman, and I am going to answer your questions today that you have provided to us either in the chat or you've emailed them to us. And so I just wanted to thank you for being with us today, and as we go through this and as I answer the questions we've already received, go ahead and include additional questions in the chat and I will answer them in the order received. Or one of our other post-conviction attorneys, Morgan Walker, is also in the chat, and she will pick up any questions that I may miss or give some follow-up or follow-up as needed. Okay, so Morgan says we're good to go, that everything is rocking and rolling. Okay, so like I said, we received some questions ahead of time, so I'm going to answer those first. And the first one comes from Leslie Wilson. She says, how long do you have to file an appeal? And that's a good question. It kind of has two parts because it depends on other things, but just kind of the basic answer is 30 days. Okay, so when the judgment is signed by the court or sentence is pronounced in open court, judge signs the judgment, you have 30 days to file a notice of appeal. Now, if you file a motion for new trial within that same 30-day window, that extends your time to file a notice of appeal to 90 days. So the bottom line, you either have 30 days if you don't file a motion for new trial, or 90 days if you did file a motion for new trial. Question number 2, why do appeals get approved or denied? And that is a question that all of us grapple with, right? Appellate counsels, trial counsels, defendants, courts, everyone. It depends on a lot of things, right? Very fact dependent, very case dependent. But really, the courts are going to grant those appeals that present strong arguments and, that really give them a reason to grant it. Sometimes we're really passionate about a case and we think that, we have a winning argument and the court still doesn't approve it. So it just, again, it's case by case, very fact dependent, and, your appellate counsel just has to try their hardest to get a win. Number 3, why do appeals take so long? That's a good question. We tell our clients all the time, post-conviction, there's nothing quick about it, right? So whether you're filing an appeal or whether you're filing an 1107 writ of habeas corpus, it takes a while. As far as the appeal process, like you just heard, 30 days, you have 30 days to even file a notice of appeal, or 90 if you filed a motion for new trial. So there you've got 3 months in the process already, potentially. Once you file the notice of appeal, the court gives the court reporter and the clerk's record a due date to file their records. Then you get your appellate brief date 30 days after that. So again, you're already at 5 to 6 months before the appellate counsel even looks at the record to determine what might have gone wrong at trial. And then an appellate counsel typically will ask for 1 or 2 extensions. You've got that 60 more days. The state gets to file an answer, of course. They can file extensions. That's 60 more days. And then once the court receives the appeal and the appellate brief has been filed, the state's brief has been filed, and it's ready to undergo review for a decision, it's anybody's guess, right? The court can hang on to that. They have no timeline that they are relegated to, so they can take as long as they need to. And we want them to take their time, right? And really give the case serious consideration. But that's the reason why an appeal can take from 1 to 2 years before you get a final decision. Number 4, Leslie asks, why are court-appointed attorneys so bad? Why do they tell us to take bad deals? We hear this a lot, right? That court-appointed attorneys are bad. And I will say just up front, that's definitely not a blanket statement that you can make. There are really good appointed counsels out there. Even in our practice, we're on appointment lists in a few counties, and appointed counsels are just as good as the attorney, right? How much they're going to put into your case, how much they investigate, how much they research, how much they, whether you're talking about a trial court appointed attorney or an appellate counsel appointed attorney. Again, there are good and bad attorneys that are appointed and retained. So I can't really answer the question, why are court appointed attorneys so bad? I just think, that there are more attorneys that are appointed, so it makes it seem like they're worse, right? versus those that are paid for and retained. There's not as many of those, so you don't get as many complaints about those. So maybe it's just a numbers game. But bottom line, if you think your attorney was bad, whether court appointed or retained, you can challenge the conviction based on that ground. And we'll get to that a little bit more as we move along here. So Leslie Wilson, thank you so much for your questions. We're going to move on to Kathleen Hamid. She also gave us some questions today, a lot of questions, but I looked over those and I think they all boil down to a basic issue, and that's ineffective assistance of counsel, right? Which we just talked about with Leslie's questions prior. So whether your counsel is, for example, Kathleen said that the court-appointed counsel didn't visit the client, didn't check on matters with police. That kind of all, falls into this category of failure to investigate, right? And if you can prove that your counsel failed to investigate, then you can establish ineffective assistance. And that's in a writ, right? So let me make that delineation and make sure that we're talking about the same thing. So direct appeals, right, are what come right after that judgment. That's when you have the 30 days or the 90 days, depending on what you file. The writ, the 1107 writ or 1107-2, whichever one you file, but the 1107 is what you file after a felony conviction. That happens after your direct appeal is final. So you've gone as far as you can in the direct appeal process, and then you can file an 1107 writ. The 1107 is largely based on most of the ones that are filed are based on ineffective assistance of counsel. Because you have a right to effective counsel, right? The Sixth Amendment says that you have a right to effective counsel. So if you can show that your counsel made mistakes so bad that they impacted your case, right, which led to your pleading guilty, or led to your conviction, or led to a crazy sentence beyond what you should have received, then you can get relief, right, based on that ineffective assistance of counsel argument. And so again, most of her questions all dealt with that issue. And a lot of what we see, we file a lot of writs, and I would say 9.5 times out of 10, we're going to have an ineffective assistance ground in our writ. And what that means is, we assert, hey, counsel made an error that was so bad that it impacted my case. But trial counsel gets a chance to respond to that. So maybe your counsel did, make a big mistake, and maybe he admits to it, right? We've had that happen. They admit, yes, I made that mistake. If I could go back and do it again, I would do it differently. But it happened. I made the mistake. And the Court of Criminal Appeals, who is the court that decides writs, would give you relief based on that ground, right? You say your counsel messed up. He agrees that he messed up. He agrees that it impacted your case. And it's not like you just get an acquittal and you're done, right? But you could get a new trial or a new sentencing trial depending on the type of ground that you argued. And we'll probably talk about that more as we go along, because ineffective assistance is just everywhere in the writ world. It's, again, one of the most popular grounds to argue. Okay, we got another question from Kay Black. She asks about the success rate of the 1107, and that is an excellent question. I would say, just doing Google search or looking on the Texas courts websites, it appears that the success rate of a writ being granted is about 3.5%, right? Which doesn't sound good, right? Because, we tell clients this a lot too, that once you are convicted, right, each step you take, whether direct appeal, if that's denied, and then you go to a PDR, maybe that's refused, and then maybe you go all the way to the Supreme Court of the United States, that's refused, then you file an 1107 writ of habeas corpus. You have already been through multiple steps where courts have said no, right? So at the 1107 point, you are looking for constitutional arguments that you can make that establish to the Court of Criminal Appeals that your rights were violated, that you deserve either a new trial or a new sentencing trial, and it's just, that's tough to do, right? You've seen it in the videos that we put out there. It's an uphill battle. That overturning convictions is tough. So 3.5% success rate is really not that surprising, and that's just for writs to be granted. Typically, just because it's granted doesn't mean you're going to get relief, right? An 1107 can be granted and you're granted a new trial, right? That means you're placed back at that point you were when you were first indicted, right? So you are, or first charged. So you're at that same place, and then negotiations can, happen with the state again. So you can talk to the state about maybe a new plea deal or more favorable plea deal. Maybe you can go to trial again. That's a really big risk to take, but it is a possibility once a writ is granted and you're granted a new trial. But a lot of our clients, they don't want to go have a new jury trial, right? It is about that negotiation with the state and to see if, you can get a new sentencing trial or a more favorable plea bargain. I'll just give an example of one of our cases. It was actually Morgan Walker's case where she did get a new sentencing trial granted. And so we had a new sentencing trial, and the judge lessened the sentence. So instead of 13 years, our client got 9 years, was eligible for parole much sooner than he would have been otherwise. And we did his parole packet, and he was released on parole late last year. And, the rest is history. He would still be in prison right now if his 1107 wouldn't have been successful and he got a new sentencing trial. So that's the way it works. Say 3.2, 3.5%, which sounds kind of depressing, but it does work, and it can work to file 1107s. All right, I am looking at. I don't see the questions, Jessica. Are there additional questions? Okay. All right, so someone asks, I have a case, but I'm poor and I'm broke. I can't find free services, not smart enough to navigate the legal system myself. So you're right. I mean, post-conviction, any type of post-conviction, whether you're talking about an appeal or a writ, is expensive because it is very work-intensive for attorneys. I will just give you an example in an 1107, right? We can present evidence, we can call witnesses, we have subpoena power once we're granted an evidentiary hearing. So it's a very involved process, and so it is expensive, almost like you're going to trial again, right? It's a second bite at the apple, although the courts don't like that saying. So there's a reason why it is expensive, but I understand that there are a lot out there who can't afford that. Now, that's the 1107 process. If you're talking about the direct appeal process, right, after conviction, you've got the 30 days, the 90 days that we talked about. You are entitled to an attorney for an appeal. So if you or your loved one cannot afford an attorney to appeal, the court will appoint you an appellate counsel. And that takes you through the appeal process, and then if that appeal is denied, that ends your time to have that you're entitled to counsel. So if you go beyond that to file a PDR, which is a petition for discretionary review to the Court of Criminal Appeals, or a writ of certiorari with the Supreme Court of the United States, or beyond that, an 1107, you are not entitled to an attorney, so you must retain an attorney for that, or file on your own, right, which is pro se. A lot of people do that, and there are people out there that are successful filing on their own. That does happen. If you have a righteous argument, usually the court, one of the overarching rules for pro se practice is the court gives you a lot of leniency, right? They construe your arguments kind of in the most favorable light. They try to interpret what you're saying. And so if you have a righteous ground, and you can't afford an attorney, just ever, it's just not going to happen, then your best chance is to bring that argument pro se. We also, here at Blizzard and Zimmerman, we offer a course where it takes you through, you just sit and watch modules from Jacob Blizzard and myself to explain, this process, the 1107 process, and how best you gather records and what kind of grounds you should argue. We even provide examples of writs that we have filed, those that are successful in the past. So that's an option. It's not near as expensive as hiring us to do the process and do it ourselves, to retain us and have us represent you. But it is an option. So it's just one of those things, right? That is there are options out there. There's a lot of free resources for people who are doing this on their own. Part of the course, right, is that you get strategy sessions with the attorney. So I'll, look over your work, or we can have an initial strategy, like how are we going to approach this? How are we going to attack this? I'll review the case as much as I can to get familiar, and then we'll, have strategy sessions. So again, that's a more affordable option. And then some people, they come and talk to us, and we might not be hired for, another 2 years down the road because they're saving money. And so that's another option as well, just to save your money and really try to, hire an attorney, whether it's us or some other attorney out here in Texas that does writ work, to do, a thorough job for you. And then another one of our questions is, how much would we charge to help me file so I can have a better chance? So I won't discuss our price structure here, but we do have a free screening process. You can call our office. I believe our phone number is there in the chat. If it's not, then Jessica can put it there for you. But again, our screening process is free. You talk to our intake specialist, Jakaya, and she will talk to you about your case. And then depending on what kind of case you have is what dictates the cost. So a direct appeal costs different than an 1107. An 1107 that stems from a guilty plea versus one that had a full-fledged trial, those cost different. So, and that's another reason why I won't go into all the costs, because it is very kind of case dependent on what we charge. Okay. Do we have any other questions right now, Jessica? Okay. I will go into a few of these more specifics that I believe Miss Kathleen Hamid asked. I told you most of her questions pointed to ineffective assistance of counsel, so I answered those on kind of a global level. But she did get into some more specifics that might help some of you out there, so I'll address some of those. Let's see. So, and again, kind of keep in mind ineffective assistance of counsel when we talk about these, and think, could that be something that I could kind of lay at the feet of trial counsel as not doing their job? Because that's an ineffective assistance of counsel ground. So this one, when the attorney, actually let me go to this one. Are judges supposed to answer letters asking for a change in the court-appointed attorney? Great question. A lot of the times, though, if you have a court-appointed attorney and you are the defendant, right, sitting in jail, your court-appointed attorney is not doing what you asked them to do, so you try to write letters to the judge trying to effect change, right? You want something done, so you write letters to the judge. The courts consider that hybrid representation, right, because you are represented by counsel, so you can't represent yourself, right? You can't have that dual representation. So the judge will likely send you a letter back, or the court coordinator or the clerk or whoever, and tell you, we received your letter, but you need to talk to your attorney because you're not entitled to hybrid representation. So sending letters to the judge will not help you in that regard. It really is about getting your counsel to seek to withdraw from your case. So he or she has to file a motion to withdraw, and then more than likely there will be a hearing before the judge, and the judge wants to know, okay, well why do you want to withdraw? And so you, the defendant, can say, look, things just aren't going well, he's not doing what I asked him to do, and you can explain to the judge at that point. So you need to at least document your request to your appointed counsel that you're asking them to withdraw, right? So the letters need to go to your attorney, and then if down the line you have an ineffective assistance ground, you have that documentation to turn to. But look, I try to get rid of this counsel over and over and over again, and then he ends up making all of these mistakes that impacted my case. So kind of all along you're just building your case for ineffective assistance, honestly. But most counsels, if the relationship is not workable, they're going to try to get out of it too, because they don't want to be part of a kind of a difficult relationship with their client either. So they'll file a motion to withdraw. The judge, though, ultimately gets to decide, and the judge might say, you know what, you two are stuck with each other. You haven't provided me enough reason to grant your motion to withdraw, so y'all are just going to have to get along. and that does happen. And again, that's just something that if that bad relationship ultimately, is impacts your case negatively, that's an argument for a future writ. Let's see. A lot of these, again, ineffective assistance of counsel, when, the court-appointed attorney shows up with 1 page of notes from the criminal's parents, and that is all. Is that a problem? It could be, right? If the performance, right, the trial counsel's performance was poor, right, was bad and impacted your case. The case law on this issue basically says it's not difficult. It's a 2-pronged test, right? Let me back up. There's a 2-pronged test to ineffective assistance of counsel. One, you have to show that your trial counsel screwed up, right? That he made a big mistake or she made a big mistake. But the second prong is the most important, right? That mistake resulted in either you pleading guilty involuntarily, or resulted in your conviction, whereas otherwise, had it not been for this mistake, you likely would not have been convicted. Or had it not been for this mistake, you would not have received the 35 years you received versus, the 15 or whatever it was. So you have to prove both of those things. The first prong, that mistake of counsel, that's the easy part, right? Because trial counsels are humans. They make mistakes, right? And sometimes, it's completely, like I said, some of them own up to them later. Like, it's not like we go out wanting to make mistakes or planning to make mistakes. Sometimes they just happen. So that first prong is easy to establish. Like, yes, there was a mistake. Not surprising, right? We're human. That second one, though, the harm or the prejudice prong, is really what the courts are looking at. So you have to establish by preponderance of the evidence, that means more likely than not, that mistake your trial counsel made impacted your case in such a way that it was really serious, right? That it resulted in your conviction, that had it not been for that mistake, the result of your trial or your plea or whatever would have been different. So if you can establish that second prong, that's when you get relief and you get your writ granted on an ineffective assistance ground. So we have people come to us and they, just like Ms. Hamid did, just pages of mistakes that trial counsel made, and that's not normal, right? That's a sign that something probably went wrong. But giving us example after example of mistakes, and that's all well and good, but you have to then show the harm that came from those mistakes, because there are some mistakes that don't result in that kind of harm. So that's the important piece of an 1107 writ. Okay, it's proving, or ineffective assistance of counsel ground in an 1107 writ is proving that prejudice. Let's see. We also asked, the judge allowed video at the proceedings but took a recorder from someone in the gallery. I'm not really sure what that's asking, if maybe there was a news station allowed in the proceedings, but then personal recordings weren't allowed, and that's not unheard of. Judges do get to determine or get to decide if they allow news coverage in any trial, but every trial is open, minus juvenile stuff, but every trial is open to the public. So you can go up to Taylor County Courthouse today and sit in on any hearing or any trial that you want to, but you cannot have a cell phone, you cannot take a call, you cannot make a recording. That's just the rules of the court. So there's nothing, malicious or wrong about that. All right. Jessica, any additional questions? Just looking here to see if there are additional questions from you guys. I know that's a lot of information coming at you, right, in these minutes that we've been here. Let's see. I want to talk to you a little bit about, because no one asked, and I think it's a good kind of foundational thing to know, the difference between a direct appeal and an 1107. I'm throwing these terms out, the appeal, the 1107, the appeal, the 1107, isn't that the same? And it absolutely is not. So your direct appeal, right, the one you have 30 days to file the notice of appeal, and then the reporter's record comes in, the clerk's record, you file your brief, the state files their brief, and the Court of Appeals makes the decision. That's the direct appeal process, okay? And when I say Court of Appeals, that's an intermediate Court of Appeals. There are now 15 of those in Texas. Depending on where you live, depends on where your appeal goes. So here in Taylor County, most of our appeals go to the 11th Court in Eastland, Texas, because that's just our region, that's our district. Now, sometimes courts of appeals become overburdened with cases, so they might transfer, the 11th court might send their case to the 8th court to be determined. That happens sometimes. But for the most part, geographically, where you live is going to determine what court of appeals your direct appeal goes to. And there are 15 of those all over the state of Texas. Now, when that is affirmed, right, like if your conviction is affirmed, meaning the appeal itself is denied, then you can file a PDR to the Court of Criminal Appeals in Texas, and we'll talk about that in just a sec. But back to this direct appeal process, right? How is it different than the 1107? And it's because we tell clients you're relegated to the record, right? So when I'm looking at an appeal case, I get the transcripts from the reporter, right? That's what happened at trial. That's just when the lady or the man who sits over typing during trial, those are her, notes, and then she turns those into transcripts, everything that was said and done at trial. So that's what I'm looking at in a direct appeal. Also, the clerk's record, that's everything that was filed into the case. So whatever the state filed, whatever defense filed, the jury charge, those kinds of things are in the clerk's record, and I look at those too. But that's all I've got, right? That's all I can make my arguments on. So I'm reading the transcript, I'm looking for objections that were overruled. I'm looking for the jury selection, and was that done properly? Did a biased juror end up on the jury panel? I'm looking at the jury charge, meaning what was the jury told, what instructions were they given at the time of deliberation, and were those correct? If they weren't, then I can argue about that. If voir dire went wrong, I can argue about that. That's the jury selection. If there were objections that were improperly overruled, if evidence was allowed when it shouldn't have been or excluded when it shouldn't have been, I can make those arguments, right? Those are the kinds of things you're looking for on direct appeal. And then I write a brief, and that's all I can do, right? The court can order oral argument if they have some questions about, like, if there's a novel issue that's presented in the appeal. But for the most part, direct appeals are decided on that brief, on the paper. I file my brief, the state files their answer, the court makes the decision on those. I cannot introduce new evidence. I can't attach things to my brief, and we're in the criminal world, okay? So a criminal appellate brief, I can't attach things to it. I can't call witnesses. I can't provide affidavits, nothing like that. It's only based on the transcript, only based on the clerk's record, and those are the arguments I can make. Now in 1107, totally different, okay? So And you heard kind of the kind of grounds I was talking about with the direct appeal. It's a jury issue. It's a, evidence issue, that happened there at trial on the record. Whereas 1107 issues ineffective assistance of counsel, involuntary plea, right? Due process violations, maybe prosecutorial misconduct. Those are all kind of these more broad, like, constitutional violations. And so that's what we're looking for in a writ. Now, to support those grounds, like an ineffective ground, I can ask for an affidavit from trial counsel. If I get an evidentiary hearing, I can call on trial counsel to testify. I have subpoena power at that point. I can reach out to witnesses that maybe the police didn't talk to, or maybe have changed their mind since they talked to the police. We can go view evidence, right? We can get experts to look at autopsy reports, or in a case that we have going on right now, we actually hired a forensic handwriting analyst to show that one of the affidavits that we're basing our argument on is a true affidavit written by the person who signed it, right? Because now that person is saying, no, I didn't sign it, that was not my signature, I didn't. So, okay, we went and got a handwriting analyst to say, well, it was you, right? You did sign this. And that's all going to be presented at an evidentiary hearing. So that is, examples of how complex writs can get. And so writs, I've talked about direct appeals taking 1 or 2 years. Writs can as well, because there is that investigation piece. We're basically treating it, some of them, like a cold case, where we're going back through evidence, we're going back through witness statements, back through police reports, things like that. So the writs definitely are a broader, and really, in a lot of ways, a more powerful tool, because we can kind of go outside of the record and make those arguments. And then, I explained that the direct appeal goes to the Court of Appeals, one of those 15 in Texas. The 1107 goes first to the trial court. That kind of freaks a lot of people out, because they're like, okay, the trial court is the one who, found me guilty or sentenced me to life, or that, that judge hates me. I don't want my case going back to him or to her. But that's just how it works. And that's, the way of things. So if there's no reason for recusal, right? And sometimes that does happen, and the trial judge is recused for a variety of reasons. But 9 times out of 10, I would say that the writ is filed there in the trial court, and then the judge gets to make a decision, not even a decision, it's a recommendation, right? The judge recommends that the writ be granted or recommends that the writ be denied. And then everything is sent to the Court of Criminal Appeals. In Texas is special in a lot of ways, but another way is that our system, our Supreme Court system, is bifurcated, meaning it's split in two. So you have the Texas Supreme Court, they decide all the civil cases. The Court of Criminal Appeals decides all the criminal cases, but they are both Supreme Court, so the highest court that you can go to in Texas. So once that trial court makes the recommendation to grant or deny the writ, then it's forwarded to the Court of Criminal Appeals, and that group of judges are the ones who make the decision to grant or deny the appeal. They make the ultimate final decision on the writ. Now, like I said earlier, granting the writ could mean, okay, I granted it, now you get a new trial, I'm sending you back to the trial court, okay, and you get a new trial, just like you would have if you would have won that new trial back in the direct appeal process, right? Or they say you get a new sentencing trial, right? Or in rare cases, but they do happen, and we've had it happen here, the court, if we establish that our client was innocent and wrongfully convicted and wrongfully incarcerated, then he is acquitted or she is acquitted, and then from there you can ask the Texas Comptroller for compensation for that wrongful incarceration, and that's based on the Tim Colt Act. You may have heard that if you've researched innocence in Texas to any degree, you're probably going to see that. So those are kind of your main decisions, right? Either a new trial is granted, a new sentencing trial is granted, or you are acquitted and you are released from prison. And as you can imagine, those happen few and far between. But like I said, our firm has had success in all of those realms. We've had new trials, new sentencing trials, and actual innocence findings. So it does happen, right? So there's definitely hope there. How are we on questions? Any questions? I know, again, it's a lot of information. So feel free to ask for clarification. Feel free to backtrack if I need to. All right. Mm-hmm. Okay, so that's a long one. This person talked about there are some videos that seemingly would show that he or she, I didn't see the author, is being stalked, but was being stalked, but their attorney says that the videos will not be admissible. I think in that, seemingly that's a, hey, this is what I'm telling you about your case. That's a tough one, right? Because admission right? Whether something is admissible or not is a decision that's made by the court, right? And even if the court says initially, no, those aren't going to come in, you're going to have to approach the bench, have a hearing outside the presence of the jury before we can decide, and we'll decide at that point whether I'm going to admit X, Y, or Z, or allow you to talk about X, Y, or Z. I think it's still worth, and depending on kind of their reasons that it wouldn't be admissible, at least trying to introduce them, especially if they're evidence of innocence or evidence of self-defense or whatever the case may be. So it's kind of one of those, just kind of an outright, no, this isn't admissible. I would probably seek further discussion with trial counsel about that before just saying, okay, fine, I'll plead guilty and take however many years. And I hope I understood that question okay. It was, like I said, it was kind of a long one, so if I didn't, feel free to write a follow-up to that. All right. Leslie, I kind of skipped over her main question, so I'm going to go back to that. What is the first thing to do first? What do you do first? And that's kind of, really, kind of obvious question, right? I mean, what do you do first? So if you go to trial and you are convicted, let's say you have a jury trial and then you have sentencing and you were found guilty, let's say you're sentenced to 25 years, right? What do you do? File that notice of appeal, right? Now, if you have grounds to file a motion for new trial, which those are listed in the Texas Rules of Appellate Procedure, your trial counsel might know those. If not, you can at least consult with an appellate attorney perhaps. But file a motion for new trial if you have grounds to file a motion for new trial. If that is granted, right, and you have a hearing on your motion for new trial, there's a possibility that you get a new trial, right, what you're asking for in the motion. If it is denied, right, you're still in the appellate process, right? You've already filed your notice of appeal, or once the motion for new trial was denied, if you're still in that window, you can file it, but you have to file it in that 90-day window. So you filed your notice of appeal and you get to proceed in the appellate process, even if that motion for new trial hearing was denied, right? Or even if you were denied the motion for new trial at the hearing. And then beyond that, I told y'all we'd talk about petitions for discretionary review. That's the next step after a denied appeal. So maybe you go through the direct appeal process, one of those 15 courts of appeals denies the appeal, and then you have 30 days that you can file a petition for discretionary review with the Court of Criminal Appeals. So you've already gone to the Court of Appeals, now you're going to the Court of Criminal Appeals, which remember is the highest criminal court in Texas, and really all you're asking them to do is look at your case, right? A petition for discretionary review means I'm asking you, court, to look at this case on your own. So this first PDR is what we call it, it's just the acronym for it. There's also a list of reasons that, it's not exhaustive, it's not all the reasons, but a list of reasons that you can file a PDR based on in the Texas Rules of Appellate Procedure as well. And so just kind of in a nutshell, the PDR is arguing that the Court of Appeals, got it wrong, right? They did something that was against other courts of appeals or against the current law, or you're saying that somehow the Court of Appeals messed it up and you want the Court of Criminal Appeals to look at your case. So that's what you're arguing in a PDR. PDRs are kind of short and sweet because you're not giving your whole argument. You're just saying, this is an issue, court, that I want you to pick up and I want you to look at my case. If that is granted, if the PDR is granted, then the Court of Criminal Appeals says, okay, it's granted. Now I want you to file the brief, right? So now you get to make your entire argument. And then you file the brief. Again, the state gets to respond. And if that's granted, again, kind of a number of things could happen. Maybe you're remanded back to the trial court for a new trial. Kind of along the same lines as if a direct appeal would have been granted, right? Or a writ would have been granted. So that's just another way to challenge your conviction is with the PDR. If that is denied, then you have 90 days that you can file a petition for writ of certiorari to the Supreme Court of the United States. I probably don't have to tell you that those are rarely granted. The Supreme Court of the United States is looking for novel issues, the things that you see in the news, right? So if it's typically a case is not going to get past that whole writ petition for writ of certiorari stage. And then once that's said and done, you've got your 1107, the post-conviction writ that you can file. And we've got another question. What can we put in a reply to the state's brief against our 2254 to make it stand out and actually get read by the federal judges? Okay, so someone just mentioned 2254, which we haven't even talked about today. That is a federal writ that comes after an 1107 is denied. So let's say you file your 1107 writ, it is denied by the CCA. If you filed that in time, which we can get into that timeline in a moment, but if you filed your 1107 in time, then when it's denied, you can then move beyond that and file a 2254 with the federal court in Texas. So that's divided into 4 courts: north, south, east, and western districts. And so you file that again, depending on your geographical location, you file into the federal court the 2254. 2254 is basically saying that the Court of Criminal Appeals got it wrong based on, they misinterpreted the facts or they misinterpreted the law. It's a very kind of simplistic way to put it. This person asked, well, what should we write in reply to the state to make sure the federal judges look at our case? If the government has been, and once you're at the 2254 level, it's the government, right? That because you're at the federal level, so it's the government, not the state. If the government has been ordered to reply to, well, sometimes they're ordered to, they have a certain time to reply, and then sometimes the court orders them even additional replies after that if the issues aren't sorted out. But you can, to answer your question, yes, you can file a reply if there are discrepancies or, the facts are misinterpreted or the government is wrong about a certain area of law or a case or whatever, then you can file a reply. Otherwise, kind of just leave it, right? You've argued what you want to argue, the state's argued what they're going to argue, and it's up to the court to make that decision as to whether to grant relief. There's really nothing you can do to kind of get this, like, kind of look at me federal judge, because that's their job, right? They're going to look at the 2254. Now, how long it takes, that's a different question. We've had 2254s that, are in the courts for a year or two before they're even decided. But they will be decided, and the court will look at them. And then, it's a little different because if your 2254 is denied, you have to then get permission and apply for a certificate of appealability to appeal that decision then to the Fifth Circuit Court of Appeals, which is the federal circuit court of appeals. So that, it just shows you from direct appeal, you can go all the way, to the Fifth Circuit Court of Appeals, ultimately, if you file the right things within the right timelines. But the Fifth Circuit doesn't have to look at it, right? They can deny your certificate of appealability. The magistrate judge or the federal judge can say, no, you don't get to appeal this. So that's just one of those things. It's you just got to be in it for the long haul, especially if you're going through a 2254. That means you've already been through a lot. But I kind of got out in the weeds with that a little bit. I'm sorry. Your 2254, once it's filed, once the government responds, it's kind of a waiting game, right? There's nothing you can do to make the federal judges move faster, if that's what you're ultimately asking. I did mention the timeline associated with 2254s. This kind of throws people for a loop. It is just one of those things. Once your direct appeal is final, right? That means, let's say you filed a PDR, right? And it was refused. And then you have that 90-day window to file a petition for writ of certiorari to the Supreme Court of the United States, right? That 90, and you don't do that, right? Let's say, I'm not going to spend the money on that. They're rarely granted, so I'm not going to mess with that. Then your appeal is final 90 days from the date your PDR was refused, right? So PDR refused. 90 days. That's the date my direct appeal is final. Then I have 1 year to file my 1107, right, from that final, the direct appeal being final date, in order to, if it is denied, be able to move on and file a 2254. It's called the AEDPA deadline, AEDPA. It's the Anti-Terrorism Death Penalty Act. And it is just a way for the federal courts to really, kind of tamper down the number of writs that they receive from denied state writs, because it's really hard to satisfy that deadline. Most of the time when people come to us wanting to file a writ, that deadline's already gone. Right now, it can be kind of resurrected, I guess, if in certain instances, like with an actual innocence claim, or if there's been new evidence, right, where actual innocence based on new evidence can resurrect that AEDPA deadline. But most of the time, if that deadline is gone, it's gone and it's not coming back. And that doesn't mean you can't file an 1107. It just means that you can't go to the federal courts beyond the state courts if the 1107 is denied. And I think we had another question after that one. No? Okay, again, we were talking about timelines and different courts and different things you can file, different kinds of arguments you can make. If y'all have any questions about any of that, please put it in the chat and I'm happy to respond. Just going through our questions to make sure that I did not miss anything. Oh, I do want to tell y'all about, so when this ends today and you decide, or you're like, man, I really wish I would have asked her about this, or I wish I would have followed up on this. We have an email here at Blizzard and Zimmerman that we monitor daily, and it's appeals@blizzardlawfirm.com, and Jessica can put that in the chat for you. You can ask any question, and we will look at those and provide you an answer within usually 24 hours. So remember that email if you do have questions after this. And then Lucy Boops asks, also, is there a timeline to file an 1107 without an appeal due to plea deal taken? Excellent question. Okay, so if you plead guilty, right, and you're right, if you plead guilty, 9.8 times out of 10, you waive your right to appeal. That's just part of the plea bargain process. So you plead guilty, you waive your right to appeal, so there is no appeal after that. The date on which the judgment is signed, right, that's the day your case is final and your conviction becomes final when you plead guilty pursuant to a plea bargain. So that's saying, I'm going to plead guilty for this number of years, I'm signing the papers, it's done, right? Then a year from that, right, you have to file that 1107 in order to then conserve that 2254 timeline. So with the involuntary plea, and a lot of, we get people that ask us, okay, well, I pled guilty, so is there anything I can do about that? And it is harder, right? It becomes a little more difficult because your guilty plea is just that. It's evidence of your guilt. To plead guilty, you sign a judicial confession saying what the state said I did it, I promise, and I'm willing to go to TDCJ for, however long we decided, like 15 years, let's say. But that doesn't mean that's not insurmountable, right? A guilty plea is definitely not insurmountable. We've been successful in the guilty plea universe. So, and what we have to prove there is that your guilty plea was involuntary or unknowing, because the law says it has to be both of those things. It has to be a knowing, voluntary plea. So if you plead guilty, you sign the papers, you end up in TDCJ, and then you're there and you realize, whoa, my attorney never told me that, I have to serve mandatory 5 years here. There's no chance that I'm going to get parole. I would never have signed up if I knew that. Right? Well, then you have an argument for involuntary plea, and you can say, my counsel was ineffective because he failed to explain the law to me. It made me plead guilty, and it wasn't a knowing or voluntary plea because I didn't know everything I should know to make that decision. And that's what you argue to the court, right? And then that's a really good one. And I say that because we had a case just like that, and it was successful, and the writ was granted, and our client got a new trial, and instead of going back to TDCJ, the state agreed to deferred adjudication probation, and he's done, right? He was out on probation and he served his time well, and he's now a free man, no strings attached. So that does happen. That was, a case, like I said, where he, on the record, the judge, the trial counsel, and the state's counsel all agreed, yes, he's been sentenced to 5 years in TDCJ, but he'll be out in 2.5 flat time. And the statute said that the mandatory time for serving that sentence was 5 years. So he would have had to serve his entire 5 years. And once he realized that, he was upset, right? He was thinking he was going to be out in 2.5, and he's going to have to serve the whole 5. So we challenged that, and again, it was really clear from the record that everyone made this mistake, right? And it's not like they were out to get him and it was malicious. It was just, nobody knew this part of the statute that said, no, this particular crime, you have to serve the 5 years. So we challenged that. It was successful. And like I said, he got a new trial, right? He wasn't just released from prison. He got a new trial. He had to go back. We negotiated with the state for deferred adjudication probation instead of prison time. And he did a great job and served that and was released. So that's how that can work out really well. And we have another question. If an inmate misses their appeal because they did not know that the writ was their only option, is their only option? I don't know if I understand that. Tammy Inglet, you've asked if an inmate misses their appeal because they did not know. Oh, is the writ, okay, I gotcha. Okay, I gotcha. So they had the right, you're saying they had the right to appeal, but for whatever reason, they missed that right to appeal. Can all they do is the 1107? That's a really good question. And it's kind of a yes and no. It's an 1107, but it's not the same kind of 1107. So, it's on the same form and everything, but it's an 1107 for out-of-time appeal. And that happens more often than, it probably should, because if a trial counsel does not tell someone that they have the right to appeal, and then they're sitting in prison and, everyone's like, well, I got my appeal within 30 days. I filed my notice of appeal. And it's like, whoa, I never got a right to appeal. I never appealed. And that right existed, right? He didn't plead guilty. The notice of appeal just simply wasn't filed. Then he has the right to file an 1107 for out-of-time appeal to the Court of Criminal Appeals, right? Because all 1107s are ultimately decided by the CCA. So he files that with the Court of Criminal Appeals, and if it's granted, he gets that right to appeal back. We've been successful with those as well. 1107s for out-of-time appeals, out-of-time PDRs, right? Because the courts are really serious about people having that right to challenge their convictions. And if the 1107, let's say the 1107 for out-of-time appeal is denied, right, for whatever reason, maybe it's been too long and they waited too long to challenge it or what have you, like 10 years, 15 years, whatever. That 1107 for out-of-time appeal doesn't count against them as an 1107, right? Because you kind of get this one shot at an 1107. But the 1107 for out-of-time appeal or out-of-time PDR doesn't count as a strike against them as having filed a writ before. Because if you file a writ, like let's say you file a straight up 1107, right? And then it's denied. And later on down the road, you want to file another one. You have to have new evidence to base that on or new law to base it on, or the courts aren't going to consider it. So that's why it's just an important kind of note to make that the 1107s for out-of-time appeals or PDRs do not count against you. It's not a ding against your 1107 filing record. So I hope that answered your question. Says Kay Black said that she's at work and she couldn't jump on. Can we repost the event? And we are going to repost it. It's recorded, so we will repost this, and that's good because I feel like I've been talking 90 to nothing, and y'all might need to slow me down or watch it a couple of times to get some of these answers. And if one of my responses is just more confusing than helpful, remember the appeals email. I'm happy to clarify. If you need clarification, and that appeals at blizzardlawfirm.com. We also have, if you've not visited our website, blizzardlawfirm.com, all of the attorneys are there, the results of our cases. You can go see our 1107 post-conviction cases, our appellate cases. and see, the things that we've done successfully, and hopefully get some questions answered there too. In a new trial, can new charges be charged? That is a good question. Yes, right? So in a new trial, new charges can be charged, but it has to, that's actually a really tricky question. I'm kind of trying to decide how that would work. So if you get a new trial, then yeah, because you're at this point of, we've had cases like that to where, there's this, you get a new trial and then additional charges are added, and we've actually argued prosecutorial or vindictiveness, right, for adding additional charges just because someone is successful at a new trial or on a writ. And sometimes that is successful, sometimes not. But that is something that the state can do, right? Because it is a new trial. So that's something that is a possibility. I would say unlikely, though, very unlikely for new. I think I've seen it happen once or twice, so an unlikely thing to happen. Okay. Any other questions? Nope, that's it. All right, it looks like we are at our hour, and so I'm going to bid adieu to everyone. And again, if y'all have questions, need follow-up, send them to that appeals email. Check out our website and the things that are going on around here, and hopefully we will hear from some of you soon. All right, y'all have a great day.